join in. Yeah, thanks for joining us today. We really appreciate you being here. Just to start with a short introduction, my name is David Hollup. I'm a counselor at PACE Business Development Center. PACE is a nonprofit community development organization based in Los Angeles. We provide comprehensive community development services that promote sustainable economic mobility for underserved communities. We have several core programs, including early childhood education, energy efficiency, housing, workforce development, and then our Business Development Center, through which we support entrepreneurs in Southern California by offering business counseling, procurement services and assistance, and access to capital. We are one of 10, well, 2 of 10 BusinessSource Centers. We have one in downtown Los Angeles and one in Hollywood, among the 10 in the city of LA. We're also an SBA microlender and a certified CDFI. So that's us. Today's workshop is part of the Small Business Legal Essentials webinar series with Public Counsel. Today's topic is commercial leasing, and there will be more workshops in this series on April 22nd. The topic will be contracts, and then on May 27th, intellectual property. At the end of the presentation, there will be a brief survey when you exit. If you could please fill that out, that helps us tailor our workshops to meet the small business community's needs more effectively. So with that, I will introduce Christine, who will start the presentation, and then we will, if you want to put any questions in the Q&A or in the chat, we can try to answer those along the way, or at the end, we'll save some time for questions. So with that, I'll turn it over to you, Christine.
Thank you. Good morning, everyone. My name is Christine Alvisures, and I'm a senior staff attorney with the Community Development Project at Public Counsel. I will be presenting today along with my colleague, Kavitha Tekchandani, who also works in the Community Development Project at Public Counsel. We have saved time at the end of the presentation for your questions, but feel free to use the chat feature, and we will try to address questions towards the end of the presentation. Next slide, please. So let's briefly go over the Small Business Legal Aid Program. The Los Angeles County Department of Economic Opportunity, City of Los Angeles Economic Workforce and Development Department, Public Counsel, and Betzetic Legal Services have teamed up to provide assistance and relief to small business owners affected by COVID-19. Through this partnership, we're here to easily connect LA County's small business owners with legal experts who can provide them with help ranging from basic legal information to representation by an attorney to help small businesses address their immediate and long-term issues. Next slide, please. Here's a list of the different types of assistance we can provide to small business owners. I just want to highlight some examples like drafting and reviewing contracts. We can provide choice of entity advice. We can assist with intellectual property issues like trademark, copyright, and patents. Next slide, please. And here are ways you can get in touch with Public Counsel. I will put this information in the chat once I'm done with my section, so you don't have to save it now, or you can save it now, but you'll also be receiving a copy of the slides. So you'll have it for later. Next slide, please. And just a quick disclaimer, this presentation provides general guidance only and should not be construed as legal advice. The law and the topics discussed in this presentation is highly context specific. The information in this training is current as of July 2025. Next slide, please. Here is our agenda for today. We will be going over SB 1103, which went into effect January 2025. Kavitha will then take over the presentation and go over general commercial lease issues and protections. And then we will conclude our presentation and have a questions and answers session. Next slide, please. So SB 1103 went into effect January 1st of 2025, and the law applies to qualified commercial tenants. So who are qualified commercial tenants? A qualified commercial tenant can be someone who is a micro enterprise with 5 or fewer employees, restaurants with 10 or fewer employees, or nonprofits with 20 or fewer employees. And the types of protections provided are language access, extended notice periods, and standards and transparency with respect to building operating costs. Next slide, please. SB 1103 applies to leases executed or tenancies commenced or renewed on or after January 1st of 2025, which includes month-to-month tenancies. And SB 1103 applies to leases executed or tenancies commenced before January 1st, 2025, if the lease does not contain a provision regarding building operating costs. Next slide, please. There are some requirements for qualified commercial tenants in order for SB 1103 protections to apply. And those requirements are the qualified commercial tenant must notify landlords of their qualified status to receive protections from SB 1103. Within the previous 12 months, the tenant must provide the landlord a written notice that tenant is a qualified commercial tenant and a self-attestation as to the number of employees. And the self-attestation is basically a written statement in which you say you are a qualified commercial tenant and how many employees you have and is signed by you. We actually have an SB 1103 guide, and the last page is a sample self-attestation form that you can fill out, print, and give to your landlord. And I will put the link in the chat once I'm done with my section. And unless the tenancy is for a period of less than 1 month, so for example, like week to week, the tenant must provide the notice and the self-attestation by execution of the lease and annually thereafter, as long as the protections apply. Next slide, please. In terms of language access, SB 1103 requires a written translation of commercial leases negotiated in Spanish, Chinese, Tagalog, Vietnamese, or Korean, regardless of whether the qualified commercial tenant negotiated the lease through their own interpreter. And a qualified commercial tenant may rescind a contract that violates this requirement. Next slide, please. SB 1103 changed the time frame for notices given to qualified commercial tenants. So it increased the notice periods for rent increases. So a landlord must give a qualified commercial tenant at least 90 days notice of a rent increase greater than 10%, and at least 30 days notice for rent increases of 10% or less. It increased the notice periods for termination of tenancies. So if a qualified commercial tenant has occupied the property for less than 1 year, the landlord must provide at least 30 days notice. And if the qualified commercial tenant has occupied the property for 1 year or more, the landlord must provide at least 60 days notice. Next slide, please. SB 1103 also addresses building operating costs, also known as operating expenses or CAM fees. And these are costs that are incurred on behalf of a tenant for the operation, maintenance, or repair of the commercial real property. And it includes, but is not limited to, maintenance of common areas, utilities that are not separately metered, and taxes or assessments charged to the landlord pursuant to property ownership. Under SB 1103, landlords must provide qualified commercial tenants with supporting documentation if they intend to charge the building operating costs. And supporting documentation is a dated and itemized quote, contract, receipt, or invoice from a licensed contractor or a provider of services with a tabulation showing how costs are allocated among tenants, and a signed and dated attestation by the landlord that the documentation and costs are true and correct. Next slide, please. So a landlord may only charge a qualified commercial tenant with building operating costs if the costs are allocated proportionately per tenant. So this could be by square footage or some other documented method. The costs were incurred within the previous 18 months or are reasonably expected to be incurred within the next 12 months based on reasonable estimates. The landlord provides a notice before the lease is executed stating that the tenant may inspect supporting documentation of building operating costs upon written request. And within 30 days of a written request, the landlord provides supporting documentation of the previously incurred or reasonably expected building operating costs. The costs do not include expenses paid by a tenant directly to a third party, and the costs do not include expenses that an insurance or the qualified commercial tenant or another third party has already reimbursed the landlord. Next slide, please. So under SB 1103, there are remedies available to qualified commercial tenants, which are rescission of the lease for violation of the language access piece. So this means if the qualified commercial tenant did not receive a written translation of the commercial lease that was negotiated in Spanish, Chinese, Tagalog, Vietnamese, or Korean, then they can rescind the lease. It can also be an affirmative defense in an eviction case. And landlords who violate the CAM fees terms may also be liable to a qualified commercial tenant in a civil action for actual damages in the court's discretion, reasonable attorney's fees and costs, and possibly punitive damages. Next slide, please. And now I will hand the presentation over to my colleague Kavitha.
Okay. Hi, everyone. Sorry, my camera for some reason is not working on here. Just happened today. So you guys will just have to look at Christine or this screen. And while I'm going to go through like commercial leases, I wanted just to kind of find out what kind of businesses you guys have. If you could just put it in the chat. I'm just curious, like what kind of businesses we have here today. Um, okay, so just to get started for commercial leases, so we're going to be talking about, like a basics of the lease, like what you want in your lease. With a residential lease, like if you have an apartment or you're renting a house, you have a lot more protections. Commercial leases, they kind of favor the landlord more than they favor the tenant most of the time. That's just how the law works. But we can at Public Counsel help you guys with your lease if you are going to rent a space and if you are like, maybe renewing your lease. Well, we can maybe look at that and see if we can do some adjustments for you if the landlord agrees, and that can help you later down the line. Okay, cool. I'm seeing a lot of interesting businesses here. Restaurants, technology sales, shop, small business counselor, private fitness studio. That's cool. Human performance infrastructure. Okay, software. Okay, interesting. Okay, those are all really awesome. A lot of like tech stuff coming up. Okay, so the types of leases are going to be, we're going to go through the types of leases. We're going to go through what your remedies are if someone breaches it, if you should sign a personal guarantee, what happens if you do, repairs, what kind of insurance you have to have, and things like that. In terms of the types of leases, you're going to see different types of leases. There's a gross lease where you have to pay just the rent, and the landlord is responsible for the cost associated with owning the property. There's the modified gross lease, which is the landlord is responsible for the costs of owning the property. But if there's any operating cost increase, then you have to help pay for that, right? So maybe there's like some new thing that happens, like maybe the roof has to get repaired and now you have to pay some of that, right? A triple net is like the NNN lease. So not only are you paying just for the agreed upon rent, but now you also have to reimburse the landlord for some of the costs, which could be like the taxes, the insurance, the maintenance. I would be careful with those triple net leases. They look really good because it's going to seem like you are paying less, like the guy maybe says, oh, you know what, rent here is only $1,500. And then you go across the street and you think, oh, well, they're charging me 2,000. But then it says it's a triple net. So now you have to help pay for the taxes and the building insurance and any type of, the gardening and everything. And so maybe your rent ends up being like 2,500, right? So you just want to be careful with those type of leases. Okay, I also see disability rights consultant. That's cool. We're actually going to be talking about ADA in a second. But yeah, so in terms of the lease terms and options, the lease is going to say, when you go and sign your lease with a landlord, there'll be an effective date that you signed it. And then there's also going to be a commencement date. That's the day you're actually going to start renting the property, right? And there's also the rent commencement date when you start paying the rent. Because sometimes, like if you drive around right now in LA, you'll notice a lot of shops are kind of empty. There's a lot of spaces, and the landlord may say to you, well, you know what, okay, you signed this lease on March 25th, but you're not really moving in until, maybe April the 1st. That's your commencement date. But we're going to give you 2 months of rent or 1 month of rent free. So your rent commencement date is not till May 1st. And so those dates are a little bit important just because, if your lease is going to expire in a year, then you have to kind of think, does it expire on the date I moved in or the date I paid the rent? So you want that to be clear in your lease. And then, renewal options. So this one's also really important, like, because let's say you move in and you're like a restaurant or something, right? And let's say you have this great Italian restaurant, you set it up and you've put in like, nice countertops and chandeliers and everything. And now, you signed a 2-year lease. Well, it's expiring and now you've got all your customers and everything. And now your rent's going to go up dramatically, right? If you want to stay there. And you don't want to pay for all the moving costs to get everything out and tell the clients to go to the other place. So it's better sometimes if you can put in that lease, like, okay, after this 1 year, 2-year lease, I have the option to renew it for another 2 years at just like a 5% increase or 3% increase, right? And that way, like, hey, if business does happen to go well here, I don't have to worry about the rent going up like crazy when the lease is over. So that's just something like, we can help you like negotiate that or put that in your lease if you want to come to us and have us look at that. Okay, yeah, the private fitness studio. Um, okay, in terms of assignment and subletting. So let's say that you have a really big space and now you want to sublet part of it, right? Like we helped the jewelry store one time in Santa Monica, and they had like a very big space, and the guy had been there for 30 years, and he couldn't, some of his clients are getting old and, they come to him for fixing their old jewelry, but now he's got such a big space and he needs to help paying the rent. Well, luckily he had an old lease and it let him sublet out part of it for other people that want to rent part of the space, right? So he was able to like kind of create like a little office and rent that, and that helped him pay. But a lot of the leases will say you cannot sublet, or they might say, okay, if you do sublet, it's subject to the landlord approving. So if we were to look at your lease, we might have in there where it says, okay, yes, it is subject to the landlord approving the person who's going to be subletting. I mean, that's kind of standard, but it shouldn't be rejected for something that's, unreasonable, right? Like, oh, I just don't feel like this other guy should be renting part of the space. Like it should be a valid reason. Otherwise, so if you're renting like a very large space, or, you think maybe it's, for example, like one of those hair salons or something, and you want to sublet part of it to some other people who do nails or something. Well, you want to make sure, right, that it says that you're allowed to do the subletting. There's also assignment. For example, like let's say that you have a great space. Now you're locked in this lease for a year, 2 years, but for whatever reason, you have to move to another location. Maybe because you're a gym, right? And now there's another gym on the same street. And you kind of think, oh, you know what? I better go to that other location where more people drive by. They'll see me. It's, more people there. Well, maybe you can assign that lease to someone else. So they just kind of take over and pay the full rent. So that's another way, so you want to look for that as well in your lease. Um, okay, sorry, next slide, please. Okay, so for defaults and remedies. So what happens if you know, you don't, okay, so if the landlord was to default, right? Let's say the landlord does something they're not supposed to do in the lease. Let's say they don't maintain the premises, it's just falling apart. Maybe the roof is caved in. We've seen so many cases with the roof caved in, you would not believe. Like, I did not think that would be a big deal, but it is, because every time it rains, I guess like, in LA, we're just not used to the rain. So the buildings are just not equipped or something. And so we have a lot of those cases. We have ones where there's really bad plumbing leaks. Like we had one last year, which was so crazy. This guy had a carniceria, which is like a butcher shop, and he had been there for over 10 years, so many customers. Well, the plumbing was supposed to be maintained by the landlord, and he wasn't maintaining it. So there was like sewer leaks coming through the floors. And it was so bad that the stench and the smell was so bad, like customers stopped coming. So suddenly he was making a quarter of the money. And then, he started getting foot infections, which were really, really bad. And so, in that case, like, what does somebody do, right? Well, we can help you look at the lease and we can help you see, like, okay, first of all, whose responsibility is it under the lease to fix the roof, to fix the plumbing, or whatever's going on? And if it happens to be the landlord's responsibility and he's not doing it or she's not doing it, then you could go ahead and sue for breach of contract and then try to recover your damages for having to leave. The trick here, though, is that I think a lot of people, unfortunately, like in this case as well that I'm talking about, you get really attached. I mean, it's just human nature. It could happen to any of us. You get really attached to the place you're at. You've put in a lot of time, you've got your customers. It's kind of like your child, right? You're just so invested in this place when you have your own business. And then sometimes, but if the situation is so bad and the landlord just will not fix it, you kind of have to make the decision. Like sometimes the landlord might let you out of the lease. They might say, you know what, we're not fixing it, but you're free to leave, right? Maybe they let you out or maybe the lease is expiring. Well, at that point, maybe you decide to leave and then you can sue them later, right? Instead of staying there forever and it just keeps getting worse. So you kind of have to make that decision. I mean, we can help you like think about that, but of course it's your decision. Now, what happens if you as the tenant breaches, right? So usually this is because you don't pay the rent. And this happens a lot because unfortunately, like business goes up and down, depending on the season and economy and, all this stuff. Right now, the price of gas. So, different things. So if that happens, then the landlord can, apply your security deposit. And usually it is quite a bit of money, right? You might have to pay two, three, $4,000 for security deposit. So they can apply that. And they can also, just end the lease and they can sue you for damages. Um, and also, if something is to happen, this is where your insurance may kick in as well, especially if there was like the roof caved in or whatever happened, right? Okay, next slide, please. Okay, personal guarantee. Oh, and one more thing, I'll bring it up maybe later, but if on that last slide when we were talking about the breaches, like if somebody breached, a lot of times one thing to be careful of is it will say in your lease that the party, if you were to get sued and the other side wins, whatever side wins has to be paid their attorney fees. So this is where it kind of gets expensive, and sometimes you might want to work out a deal with the landlord rather than going to court, because if there is a good chance that the landlord could win because like you simply didn't pay the rent, um, it does it really make sense? Like, for example, let's say like you owe $10,000 in rent, and the landlord says you owe $15,000. And you're like, oh, you know what? I'm just going to go to court and I'm going to tell the judge, and this guy's lying. And I only owe 10,000 because I, fixed X and Y and he never paid me back and whatever. Well, you have to also think like, you know what? If I go to court and there's a fee, there's something in my lease that says that the landlord or the whoever wins the case will get the attorney fees. Do I really want to pay his attorney fees? Because that could be another $5,000, $10,000, even if the judge agrees with me that I only owe 10 rather than 15. So if that's the case and there's the attorney fees clause in there, you might want to work out a deal with the landlord, right? Or you might just want to figure out like a payment plan rather than dealing with attorney fees. So if that happens, we can help, we can talk to you and figure out something that maybe you guys reach a deal. I mean, we can't guarantee it, but we can at least, get you guys to start thinking in that way. Sorry. Okay, personal guarantee. This is where on your lease it says a lot of times, like let's say you own, there's different businesses you guys brought up here, like the gym and the restaurant and repair services, whatever. So let's say you're gonna sign a lease and your company is called maybe Max Repair Services, right? LLC. Well, sometimes you can just sign the lease and it just says, okay, I'm the tenant, Max Repair Services LLC. But a lot of times they want you to have a personal guarantee. So then you have to put your name, right? Like Jane Smith or, Julie Kim or whatever. You have to put your name as the personal guarantee. And the thing is, if that happens, um, the problem is that if you can't pay the rent because, whatever, something happens, then they don't just go after your company, they're going to go after you as well. And so what we would recommend in this situation is, well, two things. If you don't have to have a personal guarantee, then don't add your name to it, okay, at the bottom. Like, don't sign your name as well. Like, I'm also signing on behalf of myself. No, you're just signing on behalf of your company. That way, only your company gets sued. But another thing is that I had a case recently where this lady had a clothing shop somewhere in the valley. And basically, when they signed the lease, business was great, everything's good. That time there were a lot of shops that were still open before COVID. And the landlord said, well, I need a personal guarantee. Well, she put down her name, her husband's name, and her 18-year-old daughter's name. Now, 10 years later, when they're getting sued because they kept on, staying in this place and they couldn't pay anymore, well, the other side is like, well, we're not just suing your company, we're suing all three of you. And she was like, well, if it was just me and my husband, we wouldn't be that worried. But now my 18-year-old daughter, who's now like in, 28 or 30 or whatever, we don't want her credit to, or, we just don't want her to get affected by this. So we kind of worked out a deal, but it's just one of those things that you don't have to put so many names, it's probably better not to. Okay, next slide, please. Okay, repairs and maintenance. Okay, so sorry, let me look at something really quick. If you guys give me a second, sorry about that. Because I have my own open as well. Okay, I got it. All right. Okay. So for repairs and maintenance, basically, like the lease should say, who has to pay for what repairs, similar to when I explained about the roof or whatever it is. Something like the roof or like the HVAC system, air conditioning, plumbing, electrical, those are usually the landlord going to be responsible for them because they're more structural, right? It goes to the whole building and the building system. But when it's something about the interior, like maybe your own, little sink or maybe, your flooring or something, that's going to be on you. That's normally how it is. Um, and then when it comes to the tenant share of the CAM, basically, these are like the CAM fees, as Christine mentioned, these are things like air conditioning or um, basically the general maintenance charges, like maybe to mow the lawn or something if there's a grass or maybe like lighting in the hallway. And, these are like the common maintenance. Well, this is calculated by dividing the square footage of the tenant's premises by the entire square footage of the building. So, and that's something that, like Christine brought up, if you are a qualified commercial tenant, then you do get that protection as well, where they need to give you it in writing that, you know what, this is how much you're going to be paying. Um, and basically, like, the typical type of lease is like, let's say it's a multi-tenant building, like a shopping mall. The tenant's going to be obligated to pay some of the costs, including maintaining the common areas. Um, and the commercial tenants, like you cannot make repairs or perform maintenance that the landlord failed to do and then take a credit unless it says that you can do that in the lease. So you know how like when you rent an apartment, for example, and the landlord is just not responding and you're like, oh, you know what? The sink is not getting fixed and this is not the flooring has this hole and then they don't respond to you after a couple emails or texts or whatever. Well, then normally you can still go make those repairs and then later try to deduct it from your rent or ask them for credit. Well, in a commercial lease, you just want to be careful because, unless it says that in the lease, you don't want to just go do that, right? So because they may say, sorry, we're not paying you back. So get it in writing. If you're going to go fix something and you expect to get paid back, either get it in writing or make sure it's in the lease. Okay, next slide, please. Okay, notice. Um, okay, so for, Christine brought up the Commercial Tenant Protection Act, which is SB 1103. Basically, this provides the tenant with protections for any of those micro enterprises. I think most of you guys might be these micro enterprises, which is 5 or fewer employees, or the restaurants with 10 or fewer employees, or nonprofits with 20 or fewer employees. So in that case, like Christine mentioned, your notice is going to be different. If they are going to increase your rent, if they're going to end the tenancy, they're going to change the lease terms, or they want to enter into your lease property, well, they have to give it to you, sorry, basically a lot of the notices, especially about terminating it or increasing the rent, that should be in your language if the lease was in your language. The other thing is if you are a qualified commercial tenant, or we call them QCT, right, that we just talked about, then if the rent is going to increase over 10%, you get 90 days notice. If it's less than 10%, like maybe they're increasing the rent 5%, well, then you get 30 days notice. And you also get 60 days notice prior to terminating the tenancy, unless you occupy the property for less than a year, in which case you get 30 days notice. So this is good just because, I mean, if you can imagine, you're a business, you're totally set up, you've got all your clients, you're I don't know, marketing, flyers, billboards, whatever. And then if someone's just going to end the lease, before it would just end really without much notice. And now, if you've been there for over a year, they do have to give you like at least 60 days notice. So that gives you at least time to negotiate something, right? Maybe you could stay longer. Maybe you could move across the street and tell your clients, hey, we're going to go there in June. So just look out for that new address, right? But it gives you that time. So that is a good law for you guys. Next slide, please. Okay, so insurance. Okay, so a lot of the leases also will say that the tenant has to have insurance, right? Because if something happens, the landlord doesn't want to be on the hook. Now, if you don't have insurance, they could later use that and say, oh, you know what? He didn't have insurance or she didn't have insurance, so we're ending the lease for that reason. Now, two practical things about this is that, like what I've seen also is that sometimes the landlord's using some kind of old lease or like some kind of standard lease that is super, detailed and really favors the landlord. And it says in there that you have to have like 5 types of insurance. So they'll be like, okay, you have to have business liability insurance. You have to have workers' comp. You have to have environmental spill insurance. You have to have, I don't know, like all this crazy stuff. Okay. And let's say like you're just working by yourself or it's like maybe you and your family member or something, and you don't even have employees and you're not, or maybe it's like you're not dealing with anything hazardous. Well, maybe workers' comp doesn't apply to you, right? Maybe the environmental hazards doesn't apply to you. So, look at what it says, or we can, send us the lease so we can look at it, because then you don't have to go and buy all these insurances. Maybe you just need the general business liability insurance, right? And that might save you some money. So, um, that's something important. And also, it is good to have business insurance because, any kind of business, especially if it's like something that someone comes into, like a store or like a restaurant, a gym, whatever it is, someone could slip and fall or whatever. So you want to make sure that there's some kind of business liability insurance so you're not on the hook for that. Um, okay, next slide, please. Okay. So, ADA, and I know somebody in here, oh, a disability rights consultant. Okay, yeah, so I did see that. Okay, so there is for ADA, this is the American Disability Act, as you guys know, or sorry, Americans with Disabilities Act. So this is federal law, but California also, adopts it. And what it is basically like if you have a store or any type of business, even if you have an online business, this could apply to you. So, it says that it needs to be accessible, right? It needs to have accessibility standards. And a lot of times it's things like, let's say you go to a store and you're paying, for something like I don't know, you go to the, Target or whatever, and you're paying for something. Well, now when you're in the checkout line, well, the counter needs to be high enough or low enough so that, probably low enough so that someone, for example, in the wheelchair can, reach over and pay and talk to you. So there's a lot of standards like that. Sometimes the hallway, like maybe you're going to like a 7-Eleven and you have to go buy some chocolate or something. Well, now, that's why I go inside. But basically, the hallway needs to be wide enough so that someone with a disability, like a wheelchair, can enter through, right? So there's like a lot of these requirements. Now, sometimes what happens though is unfortunately, um, even though there are some legitimate cases, a lot of times there's some very not legitimate cases. So a lot of you, I don't know if you guys have heard of this, where someone goes around and they will go to like a business and say, oh, you didn't have a wheelchair chair ramp. You didn't have, your door was like a 1/4 inch, too small for me and it should have been this much. And, therefore you have violated the ADA. Well, unfortunately, that small business often finds out that the person suing them has actually sued like 30 businesses every month, and they're basically a serial lawsuit person, right? It's unfortunately very difficult for the court to stop those people. And what happens in that situation is that the small business usually has to pay something to make the case go away. And the reason is because the way the law is written, it gives the person who is suing the person who had a disability, it gives them attorney fees. So because you don't want to pay like their attorney $500 an hour, you're like, oh, I better just try to settle, right? Now the question is, how do you avoid like such a big fee, right? Instead of like, because sometimes they'll sue for 50 or 100,000, $20,000. Well, in your lease, if you have like a place you're renting, you might be able to say that the landlord has to be, responsible for ADA compliance, or maybe that if there is an ADA lawsuit, that the landlord and the tenant split that fee, right? The cost or whatever. Um, so that's something that can save you a lot of money down the line, right? So that's something you just want to think about. Um, the other thing too is there's something called CASP, which basically is that it's like you can have a CASP inspector come out and it's a certified access specialist. They can come and look at your property or your business and say, okay, you know what, this looks great, or you know what, you just need, before you fully move in, what I would recommend is that the door is a little bit bigger, or you have a little ramp, or like you have, the counter is this high. That way, maybe what you do is if you're going to go and like enter into new lease and you're going to sign up for like 2, 3 year lease or something. Well, maybe the landlord would be willing to make those changes, right? And you can just pay one of these guys or women to come out and, see if it's compliant with everything. So that's another way to do things. Okay, next slide, please. Okay. This is called holdover and surrender. Okay, so like what happens if you're in your lease and, let's say you're the Italian restaurant and everything's going great and you forgot now, you've been there for 2 years and now it's 2028 and April 1st is coming up, so your lease is going to expire. And you and the landlord are in good terms, and he comes by and eats at your place sometime, right? So you guys are cool. But you've never really talked about the lease continuing. It's just like you keep paying and he keeps accepting it. But now you stayed another 2, 3 months, and all of a sudden he says to you, "Oh, I know you were paying like 3,000 a month, but actually, since you stayed here longer, past your lease, you're now in a holdover tenant. That means you've held over past the lease date, and now your rent is not 3,000 a month. Like you actually need to pay me, $3,800 a month." Well, unfortunately, that could happen, right? And it can, because what it could say is in your lease, it could say something like, if anybody stays longer and is not, past the lease term, it's a 25% increase automatically or something like that, right? And you don't want that to happen. So look at the lease, and if you think like you're going to stay longer, then talk to your landlord and say, "Oh, you know what? We're going to stay for at least another 6 months. Like, is there a way we could do a 6 month lease, right?" Or something like that. Maybe they'll agree. Um, or maybe they just accept the rent as it was paid, and that's okay too if that's what they're doing. Um, okay, so if you want to renew it, to start the negotiation early, give yourself that time. And then talking about like when you move out. So let's say now, the restaurant's moving out and they are, going somewhere else. And basically what they might do at that point is the landlord is thinking, okay, you have, I know you're moving out, on April 1st, like make sure that you have all your stuff out of the property. Well, do they, what stuff can you keep and what stuff has to stay behind? Well, let's say like when you moved in, you put up like, some new fancy tiles, you put up some, marble countertop, you put in some chandelier from Italy, and everything's looking great, right? Well, what stuff can you take? What stuff can you stay down? Does stay back. Now the landlord's gonna stay that anything that was like bolted down or like stuck to the floor or the walls and stuff like that, where it's like a new wall panel or a new flooring or something like that. That usually is stuff that stays with the landlord, actually, not with you. But if it's something that you can like pick up, like somebody could pick it up or somehow just unscrew it, like, the chandelier, that can go with you. And so what it should stay in there is like, trade fixtures, versus like what is not a trade fixture and what can go with you and not go with you. And like you want to think about stuff like signs and also like what happened. And also on your lease, you can make sure that it says that, when I leave, I get to take it with me. So that one case I told you guys about, the jewelry store, because he was there for like 30, 40 years, he had put in these like wooden kind of like panels all over the walls. And he luckily had it in his lease that said that when he leaves, he gets to dismantle all of that and take it with him, right? And he doesn't have to pay extra for any of that. So he got to take it all with him to his next place. So, make sure if you're putting in something like that, make sure it's in the lease and we can help you with that. And then abandoned property, if you leave, your property behind, just keep aware that the landlord might end up disposing it after a few days. So just, maybe you need to put in storage or something. Um, okay, so next slide, please. Okay, so now we're getting towards the end. So it's just the last section, just a few slides. Okay, so unlawful detainers, these are things where, I mean, it's an eviction lawsuit, right? So, this is usually governed by the lease. Um, the way it works is you're going to get a notice that your lease is being terminated, and maybe you decide not to leave, right? Or you get one of these notice to cure, like pay, you have 3 days to pay or quit. Like you can either pay the 10,000 that you owe or you have to leave. If you don't pay at that time, the landlord's probably going to file a lawsuit. He or she cannot just kick you out and say, oh, yeah, you have to leave like on Friday, right? No, he has to go through the court. He cannot just take over. Um, and he's going to have to file a lawsuit, which is, he has to serve you with a summons and the complaint that says, hey, this is a notice, you're being sued. And one thing to keep in mind here is that you only have 10 court days to respond. So if any of you guys ever get a eviction lawsuit, you want to, even though we don't like represent you, we don't go to court with you, we can at least point you to the direction of like maybe how you can respond or like what you can do at court, right? In your trial, how you can negotiate. So, definitely keep our phone number, which Christine put in the chat. Or maybe email yourself this as like free legal, because even though we don't help with everything and we don't go to court with you, a lot of times we do help you negotiate a good deal, and it would be probably cheaper than you hiring an attorney for like $300 an hour. So keep our number and our email address. Um, and basically, like, when you go to trial, you want to have evidence. So when you're moving out, take pictures of everything. Anytime you pay the rent, maybe keep a log of that, like your checks or whatever. Just have proof of your communications with the landlord. The landlord said he's going to fix something, he never did. Put it in a text. Say, hey, I talked to you yesterday. We talked about the fact that you're going to fix the floor by next week. Thanks a lot. If that's not correct, let me know, right? Like have some kind of proof. Um, okay, next slide, please. Um, Sorry, give me 1 second. Oh, sorry, I'm just trying to do something on my computer. Okay, notice of termination. Okay, so the landlord can send you a notice of termination that we talked about, and sometimes it's for no reason. Maybe you just, the rent, your lease is expired and the landlord just decides he wants to do something else with the property. That's okay. He is allowed to have you leave as long as, your lease is expiring or you're on a month to month because, there's nothing, no lease, you're not under lease anymore. So he can give you that, no cause notice that we already talked about, that you have to have the 60 days notice if you've been there for over a year, especially if you are a qualified commercial tenant with less than the 5 employees, or for restaurants less than 10 or less employees. Um, okay. Oh, another thing too is something different than residential is like if you're in an apartment or a house, you know how like if any of you have been evicted or maybe you own a property, you have to be very exact in how much you're asking, right? It cannot be even $1 more, or it can mess up your whole case and the court can throw it out. Well, in commercial cases, with a commercial tenant, the landlord just has to give you the estimated unpaid rent. So if it says like $1 more, you still have to respond. You still have to try to pay what, you think is, what should be due. So, if there's like a minor technical difference, you still have to try to cure that, right? You still have to fix it and pay what's needed. So just letting you know. Okay, next slide, please. Yeah, so we went over this already. So next slide, please. Yeah. Um, And, so if you do get an eviction case, there's something called discovery. They can ask you questions. They can like ask you for what pictures and documents you have. You can also ask them for what documents and evidence they have. And then at the trial, it is their burden to prove the case because they're the ones suing you. If you sue them, then it's your burden to prove the case, right? So you want to have documentation. In this type of case, all the evidence they usually need, because it's usually about unpaid rent, is like a lease and the fact that you didn't pay. Now, your defenses might be like, well, I did pay. So maybe you have like checks, maybe you have something was completely not usable, you couldn't even enter it, so you have pictures of that. So you want to start preparing your case, you want to have witnesses if you have any key witnesses, just things like that to keep in mind. But a lot of times the case will settle before the trial. I would say at least 90 to 95% of the cases, if they don't settle a few days before trial, they often settle on the day of trial. So if you have, let's say that the guy says you owe $10,000 and somehow you're able to scrape together like $4,000 or $5,000, you might be able to still work out a deal with them the day before or the day of the trial and avoid the trial. But we might be able to help you making sure that whatever settlement you enter into is not really bad for you and doesn't like totally mess up your record and stuff like that. So even if you are entering that kind of phase at some point, you can still ask us to at least look over things for you, and we might be able to do that. Next slide, please. Okay. Judgment. Yeah, so we did talk about the attorney fees, right? That's the one thing you want to be careful of. If it says that the winning party gets attorney fees, just be really careful because you might have to pay an extra $5,000, $10,000 to the winning party. And so in that case, you have to think about, does it make sense for me to go to court on this? Or should I just try to settle, right? So just keep that in mind. And we can also help you put in the right language in your lease if you have any lease. And the way of judgment is enforced is the judge will say, okay, the landlord has a writ of possession, and they're allowed to go into the property and you have to turn over the keys. Another thing is if you're moving out, you want to also always give them your keys. You don't hold on to the keys because if you hold on to the keys, the landlord will say, well, yeah, they said they moved out, but they held on to the keys and that's why we charged them for another month. So always hand over the keys, send over a letter, like a email or text or something saying, hey, John, I left the keys at your door, right? Or I mailed the keys to your secretary, right? Like just have something in writing that you did hand over the keys. And in terms of the judgment, um, sorry, give me 1 second. And we're just about, there's like just like one or two more, maybe like one more. I think this is the last one actually. Um, let's see. It could impact you in some way, like if you do get a judgment, like because it could basically impact, your access to capital, like if you want to get a loan in the future. It doesn't usually go on your credit reports anymore, which is good. But if you do want to go qualify for a loan or something, then at that point it might come up. So okay, next slide. And that is a conclusion. You can put the next slide, please. Yeah, so those are our resources. Do you guys have any questions? Okay, let's see. Thank you. Oh, thanks for the nice messages. Are there California LA regulations? Yeah, for regulations, in addition to the ADA at the federal level, California does have its own ADA type of rules as well. I don't remember offhand what those differences are. If you have any questions, like Christine just put our phone number and email address there. Let me know. We can look, or let Chris, both of us know. We can look it up for you. The other thing too, I forgot to tell you guys, if any of you have an online website, which I think is most of you probably, whether or not you have a storefront, something important is that there are now a lot of ADA cases against the website. So let's say you have a website and you are like a math tutoring company, right? Hopefully not Kumon because I went there and it was really boring for me. But anyways, okay, so let's say you have a math tutoring company and you tutor kids and you think, you know what, this is not it's, I'm doing everything online. I don't even see people. I'm probably not going to get sued under the ADA. Well, you could still get sued under the ADA because what they're saying now is, oh, you know what, your website was not accessible. So what does that mean? Well, you have to have a certain font size on, in your like on your website. It has to be visible at a certain type of, I don't know, pixel or something. It also needs to have oh, it needs to have something for voice text. So how do you, and honestly, most websites are not going to get sued. Most businesses are not going to get sued. But at the same time, do a lot of businesses get sued? Yes. Um, so a way to avoid this, you could either pay someone like $22,000 or something to fix your website, or there is something on the major, like when you guys created your website, you might have used Wix or one of these like major companies. They have a special service. It's like a widget, they call it, and you pay something between $3 and $10 a month. And they will say, look, we will make sure your website is compliant with those disability things. Now, it's not 100% compliant a lot of the times, but it might be 90%. And if you're 90% or 80% compliant, you're just less likely to get some kind of lawsuit like that. So just keep that in mind. Look it up on your, whoever your website provider is, just look up and see, is there like a monthly payment thing, like a plan for disability access? So you could look at Google for it. You could check ChatGPT, check like, how do you make your website compliant? What's the cheapest way to do that? Um, okay. Any other questions? Oh, hold on. There was another question. Christine, did you have any questions you want to answer? I'm just going to read through them, but
Yes, I think Paul has a question about the rent. So a landlord can charge whatever they want for the space. If you want, we can take a look at the lease to see what it says exactly, and we can talk further. I did put the link to apply for our services, and I can put it in the chat again if you'd like. Just let me know.
yeah, thank you, Christine. For the question about the thing I think Catherine brought up about personal guarantee, it's only required for the first year of the lease. Well, that could be the case, I think, but in the couple of cases I saw, for whatever reason, they kept that personal guarantee on their lease for like 10 years. So, the person never changed like the lease. They always had that person, they just kind of kept the old lease, which is very common in a lot of cases, right? You just kind of continue year to year without changing your lease. So they still had the personal guarantee on there. So just keep that in mind. Are there rules that commercial tenants have to follow in LA? Oh yeah, sorry. Um, well, the rules that you guys had to follow, we kind of did talk about. Most of the rules are going to be according to your lease, right? So depending on what your lease says, those are kind of your rules, and that's what the judge is going to look at as well. Um, is there a time requirement for notice of tearing down a facility and noticing for non-renewable and tenant ruined to move with heavy equipment? Is there a time requirement for notice of tearing down your facility? Oh, okay. So, this is by Ray Walker. Let me check this. Okay. So you're saying, I'm just gonna look it up really quick, but in the meantime, I don't know if you want to look at anything, Christine, but just give me 1 second. Is there... So, okay. So it looks like for Ray's question, for the time requirement you have to tear down. Okay, so let's say we talked about that Italian restaurant example, right? So when do they have to take everything down? So normally that is governed according to your lease, right? So your lease becomes your rule book, right? Like we were saying to Catherine. So that becomes your rule book, and it may say in the lease, it might say like, okay, maybe you have 5 days after terminating your lease to move everything out. It might say something like that. When it doesn't say something like that, then what you do is usually you have to do it before the lease ends or before you give up possession. Because if you think about it, like if that restaurant was to move like down the road, like maybe to San Pedro, I'm bringing up San Pedro because I have very good Italian restaurants there. So anyways, let's say you move across to San Pedro and you change, where you're gonna go. Well, the thing is, you still have your chandelier and you still have like some of your, your posters on the wall or whatever it is, in that other restaurant in, Long Beach or whatever. Well, the landlord obviously is not able to rent it out to someone else as long as you still have things in there. So you always want to try and move everything out before you vacate the property, because if you even have your stuff in there for 5 or 10 days longer, the landlord is probably going to charge you for those 5 or 10 days longer unless they agree or unless it's in your lease. If you're on good terms with a landlord, and honestly, it's usually better to try and be in good terms with the landlord unless they're really the worst person ever, because you get a little more usually, right? You get more by honey versus, I don't know what the other, how you say that expression. But basically, you can tell the landlord, hey, we worked together great for this many years. I've been paying the rent. Can you give me an extra 5 or 10 days to move this stuff out? Oh yeah, no problem. Let me give that to you. But make sure it's in writing. Make sure you follow it up with a text or an email so that later you don't get that, that invoice that, oh, now I have to pay those 10 extra days, right? Now you also had a question about the tenant ruined to move with the heavy equipment. Yeah, I mean, I don't know what exactly your question is, but if you had to move out those things, like, and you had to use heavy equipment and now it's damaged the walls or the floors or something, like you were trying to take out some heavy, like, counters or something, well, now you have to pay for that damage, and it's either going to come out of your security deposit or it's going to, maybe if that's already exhausted, they can send you, like, you have to pay for it, and you might have, and even if you move out, you might get sued in, not in the eviction court, but you might get sued in the normal, superior court, where they can come after you for like a breach of contract and that you kind of damage this property. So just be careful with that. Maybe hire someone professional rather than risking, like, if it's going to be something heavy. But again, also, like, sometimes the landlord will realize the tenant just has no money and it might be hard to collect from that tenant, right? So that sometimes happens too, but just be careful. Um, was that the end of the questions? I think that
Yeah,
was,
I think that's all the
yeah.
questions
Okay.
that I saw anyway. Um, so
Yeah, and I know we're on time, right? So
yeah. Well, I just want to say thank you to everyone for joining us, and thank you to Christine and Kavitha and Public Counsel for putting on this workshop. It was really informative, and it sounds like yeah, a lot of questions were answered, and it was very helpful. Um, yeah, on the slide here, there's their contact info if you want to reach out to them. And also just remember when you exit this, there's a survey, if you could fill that out for us at Pace. And yeah, join us for the next webinars in this series in April and May. So thank you again, everyone, and have a good day.
thanks, David. Bye. Thanks, everyone.